On March 1st, 1993, the incident leading to this litigation occurred on the site of a condominium project in Florida. On March 3rd, 1983, a clamp and hose slipped off the adapter of the air conditioning unit to which they had been attached, causing water to flow out of the hose, down the elevator shafts, and out of the main entrance doors 16 floors below. South Florida's project manager announced the same day that the incident had been caused by the subcontractor's improper installation of the hose and clamp. After the damage occurred, Tokio Marine undertook a claim investigation, indemnified for the full damages of $716,558.40, and is now a petitioner in the attempt to collect from defendants South Florida's liability insurers. Before examining the terms as they relate to insurance policies, we must review the proceedings in the district court in order to determine what issues were properly before us. The action began in May 1984 and sought a declaratory judgment as to which policy covered the loss. On June 7th, defendants filed a motion to dismiss that was followed by a motion for summary judgment by plaintiff. On July 31st, 1984, the district court granted the plaintiff's motion for summary judgment, but without prejudice to reopening if defendants should file an answer placing South Florida's negligence or the measure of damages in issue. The court thereby barred the raising of other defenses. On September 12th, upon receipt of defendants' first answer, which included an allegation that sabotage caused the accident, Judge Knapp reopened the case and referred it to Magistrate Buchwald to supervise discovery and report her conclusions as to whether there were genuine disputes of fact as to negligence or damages. An amended answer of no consequence to this appeal was also filed. On November 2nd, defendants moved for leave to file a second amended answer alleging affirmative defenses not mentioned in the previous answers. The most significant of these answers was the claim that plaintiffs had waived their subrogation rights to sue South Florida and its liability insurers for any damage covered by property insurance issued by Tokio Marine as provided under the general conditions of the contract, which are included by reference in the subcontracts. The magistrate granted the motion to amend solely to facilitate the presentation of this case to the Court of Appeals should an appeal be forthcoming. On March 19, 1985, the magistrate issued her report, concluding that no viable issue of fact existed and refusing to address the affirmative defense on the ground that it went beyond the scope of Judge Knapp's reference. Judge Knapp adopted the report on April 16, 1985, but overruled the magistrate's decision to allow defendants' motion to amend their answer, thus ruling the affirmative defenses out of the case. Judgment was entered for $716,558.40 plus interest from the date of the water damage. This appeal followed. We believe the waiver of subrogation affirmative defense was erroneously excluded from the case. At the July 6th oral argument on the parties' respective motions to dismiss and for summary judgment, defendants' counsel stated that there is no indication that Tokio Marine had a waiver of claims provision which is in the general conditions of the contract between them which may bar the claim. He also stated that defendants had not yet obtained the general conditions of the construction contract. On July 31st, despite the mention of the possible waiver of subrogation defense, Judge Knapp entered summary judgment for plaintiffs and barred all defenses except those concerning South Florida's negligence and the amount of damages.